You can transfer your home if you transfer it to the right person, your spouse, of course. We do that to avoid estate recovery. You can transfer your home to your disabled child. Your disabled child doesn't have to be somebody that has special needs. It could be to your son who had a back injury, so he can't work. You can transfer your home to a sibling, assuming that they had an equity interest for more than a year. You can transfer your home to a caregiver child. They provided care to you for 2 years in your home, and because of that, you didn't need to go to a facility, and that there's very specific rules that have to be met. For example, there can't be a private pay period that creates problems with the caregiver child transfer. But these are transfers that we think about. What can we do to preserve your assets? You can also transfer assets to a trust for a qualified beneficiary. That would be a disabled child or a disabled person under the age of 65. And there are transfers that are made after the person is on Medicaid as well. We'll talk about that. And there's also the CFC program, the Community First Choice program that I told you about, that has that lower income threshold. If you do transfers under that program, there's no transfer penalty, even though it was made the month before you applied for Medicaid. So it's a really unique option that we sometimes use to transfer assets without creating a period of ineligibility, so that the person can receive benefits at their adult family home, for example, and they transferred all their assets. There was no penalty, and it works. The issue with transfers under the CFC program is if that person's care needs increase, such that they go over to skilled nursing, they're under a penalty period for skilled nursing. So you have to look at this very carefully. Oh, and that's one of the things I want to say, and I hope you hear me. Don't do this on your own. If anything, the takeaway is, hey, there's options, but I understand it's complicated. So none of these things should be done on your own, unless potentially it's a 5-year look back and you've talked to your accountant and your financial advisor, and hopefully your estate planning lawyer too. But be very careful of doing any of this on your own.